So, whatever I will discuss in the class, just right before your test, that will be coming in your test. Okay. So, whether it is on next Wednesday, Thursday, or Friday, that I have not yet decided, I will let you know. But just be ready with the class. I mean, be regular. Then it will be uh, very easy for you to attend the questions. Okay. So where we were discussing about the acceptance, right? So the communication and offer and the communication of acceptance that we discussed so far. So anyone who just wants to, I mean, tell us a summary of what we discussed yesterday about the offer and the acceptance, when the offer and the acceptance is said to be communicated or completed. Uh, Anyone wants to answer from the offerer's point of view and from the acceptor's point of view? Somebody asked me question also at the end of the class. So anyone, please just, I mean, tell me about your understanding. Yes, Divyam. So when it
And
is
from
uh,
yes, ma'am, from the offerer's point of view,
uh,
when the offeree receives the letter, as I have, if I have posted it and when he receives it, so from offerer's point of view, it's completed communication, and from the offeree's point, acceptor's point of view, when he accepts and sends the letter, even if the other person have not received, then it is completed, I think.
is it?
Okay, so okay, so it was the opposite, right?
Yes.
Yes,
Not
so
exactly the opposite, but what you are saying about the communication is completed from the acceptor's point of view, that is actually from the proposer's point of view.
yes, ma'am.
Okay.
Yes, yes,
So that's why, I mean, the question is, I mean, this example we discussed, right? What does
yes,
it
ma'am.
mean? That I am, I mean, this is, I have communicated, say I am the offerer. Okay. So I have communicated with you, you are the acceptor. So I have communicated with you. But I have, I mean, you have not accepted. Now it may be that you have accepted and you have also I mean
Forgotten to
sent
reply.
the, you have
Like,
posted also, but it has not reached, but it is not your fault, right?
yes, ma'am.
So it is out of your control, beyond your control. So even if it doesn't reach me, but if acceptor I mean can prove that it is out of, I mean he has already sent it, so that means from the offerer's point of view it is completed. Whether
Yes,
it reaches the offerer or not, that is not the issue. But if the acceptor, he does not accept, he does not give his approval, and he does not at all, I mean, send it. So that means what? That means he has not accepted. So as an offerer, I should not take it as it is complete, the communication.
yes, ma'am.
So that's why this particular example, so where it is forgotten by the railway company's agent to post the letter. So that means it is not now out of the hand of the acceptor. So that means it is not completed, right? And from the offerers, and what is from the acceptor's point of view? The acceptor, when it comes to the knowledge of the proposer, that means when it reaches. So acceptor cannot say that, yes, I have posted, I have sent, but it has not reached offerer, so it is not offerer's fault now, right? So that means it is not completed from the point of view of the acceptor. So this is the thing. Now, when it can be revocated or cancelled, when, at what time? The communication of revocation is complete for the person revoking it when the letter of revocation is posted, and for the person to whom it is made when the letter of revocation reaches him. So it is more straightforward. Why so? Because if you now you are willing to cancel, and but you have already sent it, maybe it is not reaching the other person, then also it is out of your control, right? It is not your fault, you have posted it. So that means your revocation will be considered. For example, X makes an offer by a letter to Y on a particular day. 2 days later, X revokes his offer by a telegram. That times, I mean, long back there, I mean, these are all from some, I mean, common examples that is going on from since long. So 2 days, after 2 days, he has revoked his offer by a telegram. The telegram reaches the offeree Y after the letter. Will the offer deemed to have been revoked or not? Okay. So first he has sent the letter by making an offer. Then he revokes it. But the letter of revocation reaches after the letter of the offer. So will it be deemed to be an revocation or not? I mean, it can be revoked or not. Did you understand the question? So can you tell me, I mean, what can be the answer? I mean, anyone. Yes, yes, I can see the, I mean, hand raised. Job, yes, job.
Ma'am, I think it will be revoked because after he has sent the telegram after two
Mm-hmm.
days,
Hmm.
and so it should be revoked.
Okay, so let's see the answer. Yes. Now it is mentioned. Why you said first of all that it can be revoked?
Because he sent the telegram right
Mhm.
to
And
the
before the
offeree,
completion of the communication, it has not reached the acceptor, right?
right?
And then also before that only, I mean, he has sent the letter of revocation, and before the completion of the communication only, the revocation letter has reached. So it has been cancelled. But it has been mentioned that, so that is, you can see, just a minute, just hold on. Huh? Okay. So here you see, provided the letter of acceptance has not been posted. So now the communication is complete. The letter of acceptance, now it is not the fault of the acceptor. So he accepted. After that, the letter has reached the revocation letter. So that is not acceptor's fault. But if it is before the, so if the, that means you need to just understand that whose fault it is. So since if you are, if you have not, as an acceptor, if you have not yet received the letter of the offer, and now you have not sent your acceptance, it has reached but you have not sent your acceptance, that means communication is not complete. Now you have got, right after that you got the letter of revocation, so that means it is cancelled. You need not to accept it anymore by sending a letter of acceptance. But once you are sending the letter of acceptance, that means you already have accepted. Now it is beyond your control if the cancellation letter comes. Okay. Okay. So now another very important element of contract what we discussed is the consideration, lawful object and consideration. You remember? So what is consideration? Without which no single promise is enforceable. So something you are giving, you are getting something in return. That is the consideration, something in return. When a party promises to do something, he must get something in return. This is defined as consideration. When at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or abstain from doing something, such act or abstinence or promise is called a consideration. So that is, it is not necessarily some object, some money, some kind, not. Some act maybe or some promise of abstaining from doing something that can be also the consideration. Okay. X promises to deliver goods to Y and Y promises to pay 1,000 rupees on delivery. In this case, for X's promise, Y's promise to pay 1,000 on delivery is the consideration, and for Y's, X's promise to deliver the goods is the consideration. But there are some elements of valid consideration. All considerations are not valid. It should move at the desire of the promisor, move from any person. So we will discuss some examples. It can be past, present, or future. It of course has to have some of value. It should be real, not illusory. Something which is not possible, you cannot term is at consideration. Something other than the promiser's existing obligation. So already which is obligation exists, that you cannot, again for a new contract you cannot treat it as a consideration, and it must be lawful, obviously, right? So it should move at the desire of the promiser. An act constituting consideration must have been done at the desire or request of the promiser. So this is a very famous case. You can search in the Google, you will get it. What is that? I mean, there is a, it sometimes happens. So there's a, I mean, district collector. I think Durga Prasad was the district collector. So at the desire of that district collector, I mean, he only set up a marketplace for small shopkeepers, and then he rented that. The shopkeepers, along with the rents, they also, the term was, I mean, they need to give the collector all the goods with a discount. Now they denied, after having the marketplace for them, along with the rent, they need to give him the goods at a discounted price. Now, after having that marketplace set up, the shopkeepers, they deny to do that. They denied. Now, Durga Prasad, I mean, took them to the court. Now the problem is whether it is a valid contract or not. So since this marketplace has been set up at the desire of the not at the desire of the shopkeepers, right? They are the promiser that yes, I will pay you, I will give you the goods at a discount. So it is not at the desire. It has been set up at the desire of the collector. So that's why, since it is not moved at the desire of the promiser, here promiser means the shopkeepers who have agreed to pay him. It is a kind of, bribe he wanted, right? So that means it is not a consideration, valid consideration. It does not move at the desire of the promise. They did not say that, yes, please, set up a marketplace for us. We need to set up our shops there, right? And the next is may move from any person. So what does it mean? I mean, the suit can move from any person. It is immaterial as to who furnishes the consideration. It is commonly called that stranger to a consideration may maintain suit. What does that mean? Here is another case referred, that also you can search, Chinaya versus Ramaya. So what is that? I mean, the mother, there's a deed between the mother and the daughter, that the mother is going to give her some property or so um, to her sorry, there is a deed between the mother and her brother, I think, mother, daughter, and brother. This is the thing. Now, the deed was the mother will give the money to the brother. Now, the daughter has raised, I mean, after the death of the mother, the daughter is going to get the property. Now, the brother is not that, he's a stranger to the consideration. Now, he raised that no, since it is meant for me, so that should be given to me. So he's a stranger to that consideration, but still he can maintain the suit. So it can move from any person means the suit can move from any person. So you can, I will share the slides. You can go to the go to Google and search for the examples. Okay. Okay. It may be past, present, or future. So it must be of some value, real, not illusory. These all things I think we have discussed several times. And contracts without consideration, agreements, exceptions to general rule, no consideration, no contract. So there are some exceptions. Agreements made on account of natural love and affection. So if you are making a gift to your loved ones, so even if there is a, I mean, since it is a natural love and affection, there may not be a consideration. So now if you deny to do that, then I mean, you can be sued. Promise to compensate for past voluntary service. Okay, so if you say that, so for example, one example I gave yesterday, that that someone's son or daughter, they got lost, they are lost, and then somebody searched for, and they have found them, and then they are claiming for the money. So that is not a contract. But here it is said that promise. If you promise that yes, I will compensate you for the voluntary services is done. If you promise, then only it can be treated as the consideration. Okay. Legality of the object. The next is the legality, lawfulness. Object and consideration of contract must be lawful. Otherwise, the agreement is void. Understood. Um, it is unlawful when if it is forbidden by law. If the regulation says, if the law says it is forbidden, then it is not be considered. If permitted, it would defeat the provisions of any law. I mean, there are certain provisions of law. You need to see that whether you are doing, I mean, under that capacity, if it is fraudulent, if the court regards it as immoral or opposed to public policy, okay, then it is not lawful. So, and if considerations and objects unlawful or in part are unlawful, the agreement is void. There is one example: A promises to superintend on behalf of B, a legal manufacturer of plants, and an illegal trafficker in other parts. B promises to pay to a salary of rupees 10,000 a month. The agreement is void, the object of A's promise and the consideration for B's promise being in part unlawful. So see, here A is superintending both the thing. One is he is associated with the legal, I mean, with the manufacture of plants. That also he promises to superintend, and another illegal, in some illegal business also he is associated, but he is getting the salary together. Even if partially it is lawful, but still consideration of for B's promise, it is, even it is partly unlawful, but still it is, the agreement is void. He cannot sue for the 10,000 salary. Okay, since partly it is unlawful. So even if partly unlawful, you cannot say that, I mean, partly, I mean, you just give me the money. Partly, at least that part is legal. No, since it is um, given together, so it is void. And what are the agreements opposed to public policy? Agreements of trading with the enemy. If you are trading with some enemy country, say, agreements of stifling prosecution, agreements in restraint of parental rights. What is parents' rights? You should not act against that. Agreement in restraint of personal liberty. There are laws regarding how to keep the personal liberty of everyone. You should not interfere there. Agreements in restraint of trade. You cannot say somebody that you cannot trade here. Hmm, that is unlawful.
Ma'am,
You
what
cannot.
is enemy?
Enemy means, I mean, enemy country maybe you can think of. Okay, so there are, for example, if war is declared between two countries and it is decided that no trading will happen between two countries,
Okay.
so that you cannot, at that point of time, it is opposed to public policy if you're doing something. Okay, maybe
Yes.
when the regulations will be, I mean, relaxed, then maybe you again continue. But till that point of time, you cannot do that. Okay. So
Ma'am, I
next
have a
is
question.
your, yes, who is this?
Ma'am Aditya.
Hmm?
Ma'am, like let's say there was some part of unlawful in some consideration,
Mm-hmm.
so the person decides to sue anyway. So regardless of the verdict, if in order to sue and in order to get a verdict,
Mm-hmm.
some party would eventually prove that some part of that was unlawful. So when the crime is being like punished, does that
Mhm.
unlawful also carries a sentence, or that would be a separate case?
No, here it is mentioned. See, when if you can separate it out, I mean, if they're the two distinct incident in events or incidences, then it is fine. I mean, you can treat it differently. But here, the 10,000 money you are paying, and as if you are paying for that, as I mean, your service for the manufacturing plant. Okay, but actually, you are also assisting him in an I mean, illegal business, right? So you cannot distinguish between these two. You are paying the money of 10,000 to him. So it cannot be treated as, I mean, even if it is partly on unlawful, you cannot make it out, right? What part is for this and what part is for that. So it will be treated as, I mean, unlawful. But as I said, the example we discussed yesterday, you remember, somebody is giving loan to others, and that loan is used for what purpose you do not know. If you do not know, then it is a valid, but if you know, knowingly you are assisting someone, so that is unlawful. Here, if you can separate out the two kind of business, one is unlawful, one is lawful. So obviously the lawful, you are delivering your service, you are, I mean, delivering the goods or whatever transactions you are, I mean, you are delivering your consultancy or whatever, that is legal, that is valid. But the unlawful part is invalid. It is not, if it is combined, then only it will be treated as the unlawful. Okay.
Okay, ma'am.
Okay. The next is the capacity. Now the next element of contract, the capacity to contract. um, Ability to, what do we mean by capacity? Ability to do something, such as the mental ability to make a rational decision. So there might be two kind of inability. The person themselves are unable, or the person is able, but he is at the time of making the contract, he is not in a state of, he is not in the capacity of making a rational decision. Okay. So if a plaintiff seeks to enforce a contract, he must prove that the defendant had legal capacity to enter into a contract. So at the point of making the time, I mean, contract, that you need to remember, your friend, your next, your next door neighbor, everyone is capable of a contract maybe. But at the time of making the contract, where they're in the capacity or not, that needs to be judged. So it is an essential element of a contract because it shows that a party understood the contractual obligation. That is important. To whom you are making, whether he understands or not. Um, every person is competent to a contract who is of the age of majority according to the law for which he is subject, and who is of sound mind and is not disqualified from contracting um, by any law to which he is subject. Okay, what are the meanings? So that means if he is a minor, so then he is incompetent. If he is of unsound mind, and as I said, if he is disqualified by the law. So who is the minor person who is under 18 years of age in India? All of us know that. And it protects minors, right? Because they are not mature. So somewhere you need to make a line, right? So when you can assume that the person is mature, so here the rule is you need to attain the 18 years of age and may not possess the capacity to judge what is good or what is bad. So that is the line drawn here in India. So it is, if your agreement is with a minor, if you are making an agreement, so it is void ab initio. That means from the very beginning only it is void. There's one case mentioned, a minor executed a mortgage for rupees 20,000 and rupees 8,000 he received from the mortgage. Now the mortgagee filed a suit for the recovery of his mortgage money and for sale of the property in case of default. The court held that agreement by a minor is absolutely void against him. So whose fault it is? Knowing that you are making a contract with a minor, so that's why this knowledge is important. So knowing that you are giving it to the minor, now that you cannot claim it back. because you have made a contract with minor. Okay, so you need to be careful whether the person you are making the contract at the time of making the contract, whether he is in capacity to make that. When a person is of unsound mind, a person is said to be of sound mind for the purpose of making the contract if he understands the terms of the contract to form a rational judgment. So here, I mean, the term uses idiot in the sense that he is mentally retarded, lunatic, drunken person. Okay, so that is your fault that you are making a contract with a drunken person. You cannot say that yes, I mean he agreed. So whether he is capable of making that decision rationally, he has taken the decision, that is your fault. Now you cannot claim that yes, I mean I have the contract has been made. Okay, so these things you need to check. uh, then again, persons of unsound mind, while he is of unsound mind, he cannot enter into a contract. Any agreement entered into by him during the period is altogether void, and he cannot be held liable thereon. So it is not that, it sometimes happens that the person lunatic means all the time maybe he is not behaving that way. So while he is of unsound mind, then you cannot make a contract, that you need to prove. So while he is of sound mind, he can enter into a valid contract, and he is liable for such contracts. Okay, so that means you understood. In lunatic, by lunatic, sometimes we go through some mental problems, right? Some psychological issues, but it is not for the entire lifetime. So that means it is not that we are immature for our, I mean, whole lifetime. Sometimes we behave in a different way. It happens with many of us. So at the point of time when he is of, say, they are clinically maybe termed as lunatic, but not all the time. So the time period when they have overcome such phase, or they have not entered into such phase, then you cannot say that yes, I am lunatic, so that's why this contract is invalid. You cannot avoid your responsibility as a lunatic person. But in case of the immature persons, he cannot enter into a contract, who is always immature. So that is the point here to be um, okay, so this thing is already discussed. A persons disqualified by law, alien enemies cannot enter into any contract. As I just discussed, foreign sovereigns and ambassadors can enter into contracts, enforce those contracts in our courts, but cannot be sued in our courts without the sanction of the central government. So you just understood, I mean, how careful you need to be when you are entering into some contract with the foreign ambassadors. Um, so the contracts can be enforced in our courts, but cannot be sued in our courts without the sanction of the government. So it is risky, right? And with the convicts, you cannot make a contract, cannot enter into a contract during the period of sentence. Again, just like the lunatic, the period he is of unsound mind, you cannot make a contract. Convict is during the period of sentence. When he is out of that sentence, then I mean you can always make a contract. It is not invalid. But during the period of sentence, the contract cannot be made. Here is one example of an alien enemy. Ex-an Indian carries on a business in Pakistan. He enters into a contract with Y, who carries on business in India. So immediately after the formation of the contract, a war broke out between India and Pakistan. In this case, X becomes an alien enemy, though he is an Indian, and the contract between X and Y will be suspended for the duration of the war and revived after the war is over. In this example only, I mean, mentioned. So here, see, again, during that period of war only, you cannot, even if he is an Indian, he is doing the business in Pakistan, but he is Indian in origin. But during that period of that war broken, you cannot make a contract. The contract is not valid. You can make, but it is not valid. Okay, another person who is not be able to enter, who is not in the capacity, that is the insolvent, cannot enter into contracts relating to the to his property. When the insolvent is discharged, the disqualification is removed. Okay. Okay. So this is all about the capacity. So today we have discussed the consideration, the lawful object, then the capacity to contract, the three elements. Then comes the another important element, that is a free consent. The consent must be free. It must be at the will of the acceptor. Okay. So what do we mean by free consent? It is essential to the creation of the contract that the parties are ad idem. What does it mean? They agree upon the same thing in the same sense at the same time. What you are understanding now, you have made a contract and you later on said that no, it is not the same. At that point of time only, what I have understood now, I am thinking it is a bit different. You cannot say that. At the same time, same thing in the same sense. Um, Consent means an act of assenting to an offer. So two or more persons are said to consent when they agree upon the same thing in the same sense. Effect of absence of consent: when there is no consent at all, it is void. It is not enforceable at the option of either party. Now, two or more persons are said to, okay, consent is given. Okay. A agreed to sell card to B, but A has two cards X and Y. A thought of selling card X, where B thought of purchasing card Y. Okay, so they are not agreed upon the same thing in the same sense. So since there is no consent, there is no contract. Now the question is, consent is said to be free. The five things you need to remember, four things: coercion, undue influence, fraud, misrepresentation. Yes, five, sorry, fraud, misrepresentation, and mistake. Now there are differences between fraud and misrepresentation and mistake. How they are different, I'm coming to it. No free consent. Contract is usually voidable at the option of the party whose consent was not free. So what do we mean by voidable contract? What is the difference between void and voidable contract? I have discussed in the last class. Anyone? What is voidable contract and what is void contract?
I'm like contract is something like it was
Who
never
is answering? Divyam.
so
Divyam, let others answer. Let Abhijit answer. Okay.
Ma'am, void contract is illegal and unenforceable, whereas voidable
Mhm.
contract is legal and enforceable.
And what is valid contract?
Ma'am, valid, which is voidable.
Voidable is valid. Are you agreeing, Divyam?
Voidable is not valid, but it could be valid if some points are corrected.
Hmm.
But void contracts are something like if A asks B to kill somebody, and that's a void
Mm-hmm.
contract because it is illegal, completely illegal. But voidable contract is if some points are
No,
not right.
Abhijit's point is correct that void contract is, if it is not, if it cannot be enforceable by law, and to make it enforceable by law, whatever elements of contract we have discussed, that must be there, right? That is
Yes.
about the void. But what is about voidable? You said that if there is some correction, then it can become, I mean, it cannot, I mean, it can become valid, something right
Yes,
like
sir.
this, right? Okay, Saurav, you want to ask, tell something?
yes ma'am, like
Huh?
voidable contract is like something, I mean yeah, as Divyam said that there are some points which
So
needs to be
when a
corrected and
voidable
the party.
contract, say you said that, I mean, when a voidable contract, it is, I mean, without changing the terms and conditions, when a voidable contract becomes valid. What do we mean by voidable?
When both parties are
If it is
like
voidable, say for example, you are saying that if the terms are changed, so if the terms of the contracts are changed, then it becomes valid, right? So if the terms are not acceptable by the parties, so why the contract has been made at very beginning? Contract should have not been made, right? If both the parties are not agreeing, then why the contract has been made? How can a contract, when there is a contract, there must be that the two parties has agreed, has given their consent, isn't it? So if both the parties have given their consent, then why it is void? Why there is a, I mean, where is a void part coming here? Why it is voidable contract? Yes, Shreyash?
Because if even if the consent is given, if it is
Yes.
not free consent, then it can be
Yes.
voidable
So
and
that
also.
means what? That means the consent, I mean, there is a contract between two parties. Now, one party has, two parties have agreed, but you don't know whether it has been, I mean, agreed upon by forcefully or willingly, right? So the consent is there, but whether it is free or not, we do not know. Now, when, if it is so, say for example, one party has, I mean, offered and one party has given his consent, but again, it is not willingly he has done it. Okay, knowingly he has done it, whatever it may be. So it is voidable. We understand. Now, this particular contract, when it can be made, when it can be valid, that also I mean, discussed yesterday. Yes, Shreyash, can you answer?
Ma'am, if
When it
both
can
have given
become
free
valid?
consent,
No, now
uh,
it has already been made and it has not been given by free consent. So,
okay. So, ma'am,
so
if both the parties agree, if the person
they
whose
have
consent
agreed
was
and
not free,
they have agreed and one party's consent is not free. That we know. Now, how it, when it can become valid?
if the person whose consent was not free chooses
Mhm.
to stay in the contract, then it can be
Yes,
valid.
yes. So if the aggrieved party and that too within a stipulated time period,
Okay,
if
yeah.
they cannot, I mean, say that, if they do not say that, I mean, no, I mean, it has been not agreed upon by, I mean, willingly by me. So that means the consent, I mean, he is not um, raising his voice. So that means he is accepting, and that stipulated time period has also passed. So that means this voidable contract is no more voidable. It is your fault that you are not, I mean, raising your voice. Okay, so that means it becomes valid then. So that is the, I mean, voidable is in between void, which is void from the very beginning, or I mean, because of some, again, some public policy or unlawful or whatever may be the absence of the elements of contract, because of that it becomes void, or it may be totally valid. But in between that, there is a voidable, which can be made valid, which can be made void. Okay, so that is the difference. Now,
Ma'am,
yes.
ma'am, if the party who is coercing the other party, if
Mhm.
they coerce them for like the more than the stipulated period of time,
Mhm.
so wouldn't then the contract be valid
Now,
because
you
the
do
part?
not know for that particular incident what do we mean by the stipulated time period, right?
Yes.
And there are different types of free consent, as I mentioned here: coercion, undue influence, fraud, misrepresentation, mistakes. So every types of consent differ from one another. Okay. So that case to case basis, it needs to be judged. Okay. Now, first, let us start with the coercion. Now, what is coercion? A contract is said to be caused by the coercion if it is obtained by committing any act which is forbidden by the Indian Penal Code, threatening to commit any act which is forbidden, again, unlawful detaining of any property, threatening to detain any property. So it is a kind of threat continuously. I mean, it is talking about a threat. Um, okay, so this is, I mean, the simple example given. Okay, just read these examples. A person, I mean, he was, I mean, fired, maybe here the example is, but he is not ready to release the liabilities from his principal by refusing to hand over the books of accounts. So he is the employee he will only leave if with the condition that he is not going to hand over the books of accounts to his employer. The release date was held to be, so this kind of contract he wants to make. So it is voidable at the option of the principal. Now if the principal says that okay, you take my books of account, I will and you will be released. So if the principal does not um, uh, raise his thing, so that means this is voidable at the option of the principal. Okay, so if the principal says that no, it is not, it cannot be done, so then only it becomes a void contract. The contract of the contract is voidable at the option of the party whose contract is being caused by the coercion. Okay, so got it. So coercion, it is always, so you need to, as you, one of you just right now you asked me that whether it is within the stipulated time period or after the stipulated time period or not. So obviously it is not that once he has taken the books of accounts and then you are saying that yes, it has been done by him. So there must be, it is not that 10 years back he has done something and you are now telling that you have done it. So it depends on, the judgment, it depends on the situation, analysis of the situation. So if it is a continuous kind of threatening or coercing is happening over the 10 years point of 10 years time period, and that's why he is not able to raise the issue, so that means it is, the stipulated time is not over. Okay, so that's why it is not mentioned that it is 10 years or 5 years or 6 months or 7 months. It varies case to case, from case to case. Okay, the next is the undue influence, dominating the will of the other person to obtain an unfair advantage over the other. So how we can dominate? Sometimes the parties to the agreement are related in such a way that one of them is able to dominate the will of the other, right? Sometimes, say for example, a doctor and a patient. So doctor, as a patient, you don't know, you are a layman, and doctor knows many things. So doctor can exploit you, right, if they want. So I'm not trying to demean any kind of profession, but this is just to make you understand. So for example, a lawyer, you are going to the lawyer for some legal consultancy, but he knows far better than you, so you do not know those terms, so he may exploit you. So it is the kind of, relationship where one party can dominate on another. It creates a mental or moral fear created by coercion. Consequently, the party on whom undue influence is exercised is indirectly compelled to enter into the contract. Sometimes we also, even the teacher and the student relation, right? Sometimes as a student, you are afraid of raising your voice because maybe it will affect your academics. As a patient, the patient party sometimes they are afraid of raising some issue with the doctors because the doctors can do harm to them. This is a kind of fear. It is there, right? So it is called the undue influence. And if by taking that, opportunity, if somebody exploits, there is an undue influence he is making. So example is A having advanced money to his son B during his minority. So this is a relation between the father and son. Just see, obtains by misuse of a parental influence. Sometimes parents also, there are the cases where parents also use that kind of influence, a bond from B of a greater amount than the sum due in respect of the advance upon B's coming of age. So A thus employed undue influence. Okay. So by a father-daughter relationship, by having a dominant kind of relationship, he is taking the undue advantage. Okay.
Ma'am,
Now, yes.
ma'am, but since the son was a minor, wouldn't the contract be automatically invalid?
That is why that is what I am saying. So for example, this example I am going to give you in your exam, and I am asking that what is the reason that it is not a valid contract. So you can raise that issue also. The person he is making the contract with is minor, you can say, give the example of that undue influence also. Okay, so that is also another point. Because of the minor, you cannot make a contract with him. Okay. Now, if he's not a minor, say he has already attained the 18 years of age, but it is not that he has yet to get a job. So then also it is an undue influence. You are giving the money to his son, to your son, and then after getting the job, you are trying to get back a huge amount of money. So that is also an undue influence example. Okay. So, but there I want to mention that few relationship where it is called that there is a relation. These relationship generally this holds between, as I said, doctors and patients, lawyers and their clients, and the father-son relationship also we have seen. But there are few relationships which are out of the purview of this thing. So, for example, the relation with the father is considered as the undue influence can happen, but the relationship with the mother is not. Okay, and that is, I mean, the legal rule. It is not that you are considering your mother and you are not considering your father. But in the books of law, you'll find that the relationship of mother with the mother and the father, they are seen in a different way. Okay, so these are not the issue of this topic. So that's why it is just to let you know. Then it comes the fraud. Now, fraud indicates, now see all kinds of the free consent examples, how different they are. One type of absence of free consent is coercion, another is the undue influence. So those all the things are different from each other. Then comes the fraud. Here, nobody is coercing another, nobody is taking the undue advantage, there is no undue influence. So, here, what it is fraud. So, you are misguiding someone, right? So, fraud indicates willful misrepresentation. So, you knowingly you are misrepresenting the fact. It means and includes any of the following acts committed by a party to a contract or with his connivance or by his agent with intent to deceive any other party. So intent is there, which is important. You are intending to deceive another party, there to of his agent, or to induce him to enter into the contract. So by deceiving other party, you are entering into the contract, and the other party is also giving his consent. So the representation that a fact is true when it is not true. So what are the meaning of the misrepresentation? The representation that a fact is true when it is not true by one who does not believe it to be true. You yourself know that it is not true, but still you are delivering it as a fact. The active concealment of a fact by one having knowledge or belief of the fact. So you are actively, you are concealing something. So one is you are misrepresenting, you are disclosing, but it is not right, you know that. Another is there's a concealment of a fact. Third is the promise made without any intention of performing it. Any other act fitted to deceive, any such act or omission as the law specially declares to be fraudulent. Okay. Uh, Now, this is important. Mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud. Now, as I said, that active concealment. Now, mere silence, is it a fraud? No, unless the circumstances of the case are such that regard being had to them, it is a duty of the person keeping silence to speak, or silence in itself is equivalent to speech. So that means mere silence, active concealment is fraud, but mere silence is not fraud unless it is the duty of the person who is keeping the silence to speak. If it is proved that it is your duty that you should speak and you remain silent, then it is a fraud. Or your silence itself, silence means that you are accepting, that is already equivalent to speech. That means this is fraud. Okay. So mere non-disclosure, I'm coming to the example, mere non-disclosure is not fraud when there is no duty to disclose. So caveat emptor or buyer beware is the principle in all contracts of sale of goods. see the example. This is interesting. A sells by auction to B a horse which knows to be unsound. A says nothing to B about the horse's unsoundness. So this is not fraud. What do you think? This is fraud or not fraud? Now see the second one. B is A's daughter and has just come of age. Here, the relation between the parties would make it A's duty to tell B if the horse is unsound. So see
No,
the
ma'am.
difference. Yes,
But B should also clear the.
the first example, right? The first example you are okay. Now coming first, let me read this. Examples of fiduciary relationship: principal and agent, solicitor and client, guardian and ward, trustee and beneficiary. So what is tried to be communicated here is there are some relationship which is the fiduciary relationship, principal, agent, solicitor, client. That means uh, trustee, beneficiary, doctor, patient, guardian. What do we mean by that? So if you are seeking some consultancy from your solicitor, okay, or if you are seeking some consultancy from your doctor, if there is a relation between guardian and ward, the point is everything needs to be disclosed. Everything, it is expected. Just remember the difference between the your business law and general law that I discussed in the last class. That is, in business law, it is presumed that there is a, I mean, binding from both the parties. But in case of general law, it is not presumed, right? So similarly here, the examples that I mentioned here, there you need to disclose. So if you are seeking a consultancy, a help from your solicitor and you are not disclosing it, if you as a patient you are not disclosing that what exactly is going on, the doctor cannot give you proper advice, right? So the relation, it tells that you need to disclose everything. Now the question comes, the number one, that when there is a customer and supplier relationship. Now the point is, why it is called the particular phrase caveat emptor or buyer beware. There is a duty of the buyer. That is very important. I will also cover it in Sale of Goods Act, that there is a duty of buyer to specifically know that what is the product all about. If the buyer comes and without asking about the quality of the product, he just takes the product without interrogating about the product, so it is the buyer's fault also. It is not only the seller's fault. So let the buyer beware is a very important term in Sale of Goods Act, this kind of contract. Okay, this is called the caveat emptor. You cannot escape as a buyer that you have not asked for the, so let you, I mean, you ask, then if the seller says that no, the horse is of sound, um, uh, then if he claims that the soundness of the horse, then the buyer can sue the seller. But you have not, as a buyer, you have not checked, you have not investigated, you have not asked a single question, and you have trusted the seller. So that is not the, I mean, it is to protect the interest of the seller also, this law has been made. So it is called the caveat emptor, or let the buyer beware. Buyer has to be beware of the product or service he is going to take. Okay, so I will also what is the time? Okay, just 2 minutes
Ma'am,
left. Yes.
ma'am, I had a question in the previous A part when the B sells the
Yeah,
horse to
just
A.
coming to this. Just read this. Now, if B says to A, if you do not deny it, I shall assume that the horse is sound. A says nothing. Here, A silence is equivalent to speech, right? Okay. So that means if B says that I am assuming that it is a good quality and he is telling nothing, then it is a fault, then it is a fraud. Okay, a silence is equivalent to speech. That means A is accepting that yes, the product is fine. You understood? The it silence is equivalent to speech. That means the A is accepting, then you can make a suit. Now A and B being traders enter upon a contract. A has private information of a change in price which would affect B's willingness to proceed with the contract. A is not bound to inform B. Okay, Yes, now you ask.
Ma'am, like the person who was selling the horse, let's
Mhm,
say he was not aware of some rare physical disease that the horse had, but
mhm,
when the buyer buys the horse, in the
mhm,
next few days, the horse suffers from some
mhm.
disease,
Yeah.
and but so basically, is the buyer wants to sue the seller that you did not disclose me about
Mm,
the
mhm, mhm,
horse's condition, but the
mhm.
seller says that he himself was not aware of that condition.
Yes,
So
that examples also is there. So if it is can be proved, so that is not fraud, that is misrepresentation, that is mistake. That I will discuss in later tomorrow's class. Okay. So if both of them are, I mean, they are really unaware, then maybe it is a case of, it may lead to the suffering of one of the party, but then also it is a kind of misrepresentation. But there the fault is of none, right? But if he is willingly doing that, he is intending to misguide other, then it is a fraud. And if the other one, the buyer, that buyer party, that they have, even if, yes, I'm taking this product, so it is good, right? There is no problem. And if he does not say anything, so even that is a silence, he is keeping silence, but then also he is intentionally, he is making, he is misrepresenting the fact. So then it is his fault. Okay. So I will discuss the misrepresentation and mistake in tomorrow's class. So then it will be more clear to you. And I will also give a good example. Okay, let me just take your attendance.